I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. John Eastman, Donald Trump's lawyer, who was ordered last week to turn over additional records to the January 6th committee based on the crime fraud exception to the attorney-client privilege, is trying to challenge the finding by the federal court in the Central District of California that the crime fraud exception applied. And John Eastman is saying there's additional information that he wanted to show the judge that gives more context, that he actually wasn't engaged in crime and that he was just trying to get all the facts right. John Eastman has filed a motion in federal court before federal judge David Carter, and it's called a motion to reconsider, or in the alternative, for a stay pending appeal. And in this motion, John Eastman is saying that Judge Carter got it wrong in his October 19th ruling. In Judge Carter's October 19th ruling, he was evaluating records that John Eastman had withheld from the January 6th committee's subpoena, and he had asked a federal judge, in this case Judge David Carter, to make a judicial finding that all of these records that he was withholding were subject to the attorney-client privilege based on John Eastman's purported attorney-client relationship with Donald Trump. The case was filed in the Central District of California because at the time of the January insurrection, John Eastman was using an email account from Chapman University, which is a law school in California, right around the Orange County area where John Eastman used to be a professor, and he used his Chapman email account to communicate about these election crimes that he was committing. Judge David Carter, a very well-respected federal judge who's been a judge since 1981 and a federal judge since 1998. He's a Clinton appointee. He reviewed all of these records that John Eastman had turned over. He reviewed these records through a process called in-camera review, I-N space camera, C-A-M. ERA, which basically means the January 6th committee doesn't get to look at those records until the Judge David Carter makes a finding in order to preserve the attorney-client privilege, unless, of course, the attorney-client privilege doesn't apply or there are exceptions. And after conducting a very rigorous review, Judge David Carter made a scathing finding on October 19th. We've covered it here on the MeidasTouch Network, but Judge David Carter found that Donald Trump and John Eastman were engaged in a coup in search of a legal theory. He had actually made that finding in a prior order a few months back, but here he reiterated that there was a crime that was committed, in his view, between Donald Trump and John Eastman, and that crime was more likely than not committed. And those crimes include obstruction of the proceedings on January 6th and a conspiracy to essentially defraud, but to overthrow our democracy when you break down what that conspiracy is. But as Judge David Carter explained in his very detailed ruling, for attorney-client privilege to be vitiated, there is a two-step process. First, there has to be a finding that there is a crime that was committed. And Judge David Carter said, I had previously made a finding that this was a coup in search of a legal theory, that there was criminal conduct here. But now I have to look at all of these remaining documents left, and Judge David Carter had previously ordered other documents under the crime fraud exception go to the January 6th committee, but he was now analyzing a final batch of about 500 plus records. And he says, for step two, I then have to determine if the documents at issue were in furtherance of the crime. Because if they were in furtherance of the crime, then the crime fraud exception applies. It's a two-step process. One, was there a crime? Two, were those specific documents or emails detailing the crime or in furtherance of the crime? And Judge David Carter found that yes, indeed, that the documents at issue were in furtherance of a crime that was being committed between Donald Trump and John Eastman. And there's two specific categories. The one that got a lot of attention was the category 2 that was listed on page 16 of Judge Carter's October 19th ruling. And Judge Carter called this category emails related to and in furtherance of the conspiracy to defraud. And Judge David Carter writes, 4 emails demonstrate an effort by President Trump and his attorneys to press false claims in federal court for purposes of delaying the January 6th vote. The evidence confirms that this effort was undertaken in at least one lawsuit filed in Georgia. On December 4th, 2020, President Trump and his attorneys alleged in a Georgia state court action that Fulton County improperly counted a number of votes, including 10,315 deceased people, 2,560 felons, and 2,423 unregistered voters. President Trump and his attorneys then decided to contest the state court proceeding in federal court and discussed incorporating by reference the voter fraud numbers alleged in the state petition. On December 30th, 2020, Dr. Eastman, John Eastman, relayed concerns from President Trump's team, quote, about including specific numbers in the paragraph dealing with felons, deceased, moved, etc. The attorneys continued to discuss the president's resistance to signing when the specific numbers were included. That's a quote. And Dr. Eastman explained the next day, and this is also a quote. Although the president signed a verification for the state court filing back on December 1, he has since been made aware that some of the allegations and evidence proffered by the experts has been inaccurate. For him to sign a new verification with that knowledge and incorporation by reference would not be accurate. The court goes on to say, President Trump and his attorneys ultimately filed the complaint with the same inaccurate numbers without rectifying, clarifying, or otherwise changing them. The emails show that President Trump knew that the specific numbers of voter fraud were wrong, but continued to tout those numbers both in court and to the public. The court finds that these emails are sufficiently related to and in furtherance of a conspiracy to defraud the United States. It's a significant finding there. And then the other category are emails related to and in furtherance of delaying or disrupting the January 6th congressional proceedings. Judge Carter ordered these records be turned over as well because they were in furtherance of the crime. And Judge Carter says there are 4 documents here in which Eastman and other attorneys suggest that irrespective of the merits, the primary goal of filing is to delay or otherwise disrupt the January 6th vote. In one email, for example, President Trump's attorneys state that merely having this case pending in the Supreme Court not ruled on might be enough to delay consideration of Georgia. So Judge Carter said with those 8 documents, he said the other ones were close calls. Carter could have ordered the remaining 500 documents turned over, but he said, look, from this batch, about 8 are clearly in furtherance of the crimes. I'm ordering that John Eastman turn over those emails to the January 6th committee. And what does John Eastman do? He now filed this motion to reconsider. And he's saying, Judge Carter, respectfully, please reconsider your prior order that I'm a criminal and that I engaged in these crimes in these emails and that these emails demonstrate the crimes that Trump and I were committing. And look, take it easy on me, Judge Carter. If you're not willing to reconsider, can you please just stay or stop the enforcement of your order so I don't have to turn over these emails to the January 6th committee until I can appeal it to the Ninth Circuit? And then maybe, just maybe, I can go to my friends at the Supreme Court and they could try to help me out and bail me out here. That's what the second part of what John Eastman's motion is, where it's a motion to reconsider, or in the alternative, for a stay pending appeal. So the stay pending appeal is Eastman asking Judge Carter, can you please just hold off on allowing the January 6th to enforce it so then I could appeal? And what John Eastman actually says here is he goes, this is from John Eastman's filing. I'm reading from the filing right now. Eastman goes, This court also held that a few emails, quote, make clear that President Trump filed certain lawsuits not to obtain legal relief, but to disrupt or delay the January 6th congressional proceedings through the courts. Dr. Eastman submits that the full email record demonstrates that the legal filings were all designed to obtain a ruling from the court on the contested election challenges. And then he also says regarding the finding that Trump knew that the specific numbers of voter fraud were wrong, but continued to file those numbers in court and in public, Eastman goes, Dr. Eastman submits that the full email record, just look at the full context, it shows that the president's lawyers took great care to ensure all court filings were accurate. He goes, the court also held that a few emails made clear that President Trump filed certain lawsuits not to obtain legal relief, but to disrupt or delay. Eastman will submit the full email records there as well. So I want to remind you all, too, what Donald Trump did immediately after Judge David Carter made the ruling that the crime fraud exception applied. Let's pull up what Donald Trump posted on his social media platform immediately after, shortly after the October 19th ruling by Judge David Carter, which Judge David Carter is no doubt aware of, and the January 6th committee is no doubt aware of. This is what Trump wrote. Who's this Clinton-appointed, quote, judge, David Carter, who keeps saying and sending to all very nasty, wrong, and ill-informed statements about me on rulings or a case, whatever, currently going on in California that I know nothing about, nor am I represented. With that being said, please explain to this partisan hack, he called the judge a partisan hack, to this partisan hack that the presidential election of 2020 was rigged and stolen. Also, he shouldn't be making statements about me until he understands the facts, which he doesn't. Oh, he doesn't understand the facts, Donald Trump? I mean, those emails that I read were unclear about your lawyer saying that the information in your verifications were false. He doesn't understand that there was a crime that was committed on January 6th. You want to challenge those findings? Here's what you need to do, January 6th committee. In your response, because you're undoubtedly going to win, at least before Judge David Carter, and I believe the Ninth Circuit Court of Appeals, if John Eastman then files an appeal, you need to attach that social media post by Donald Trump. You need to post it in your filing so that the judge knows that Donald Trump, what he's saying, that the election was rigged and stolen, which is showing and demonstrative that it is in furtherance of the criminal conduct at issue. Precisely what is in Judge Carter's order, that Trump is still going about making these false claims. He's also challenging that the judge is, quote, a judge. And also, when Donald Trump says that I'm not represented, Donald Trump, your lawyer is John Eastman. Your lawyer is the one who filed and initiated this lawsuit before Judge Carter. That is how this case is even before Judge Carter in the first place, because it is your lawyer's lawsuit. And you have been quiet other than in your social media post. So here's what I think the January 6th committee should do as well in light of this motion for reconsideration. I hope you're listening, January 6th committee. Ask for an evidentiary hearing in light of what John Eastman is asking for, and subpoena Donald Trump. Ask Donald Trump to show up in federal court before Judge David Carter, have him address the crime fraud exception issues, have him address that statement that I just read to you, have Donald Trump address his conduct, because he's been the one who's notably silent. Let's put Donald Trump under oath. I bet you he pleads the fifth. It is a perfect opportunity for the January 6th committee to do that now in response to what was just for the motion for reconsideration that was filed. You had John Eastman submit whatever affidavit he is saying that he's going to talk about the overall context of these emails and how the judge needs to understand the context. Okay, you want to understand the context? Let's bring in the client. The client is the one who actually holds the attorney-client privilege. The client claims, according to this post that I just read, that he doesn't know anything about these proceedings. He doesn't know anything about the proceedings. So call in Trump before Judge Carter and let's have an evidentiary hearing and let's ask Trump the questions directly as well about those emails and about those verifications. You have the perfect opportunity to do that right now, January 6th committee. I hope you take my advice there. But that's the motion that was filed by John Eastman. The motion filed by Eastman was to asking the judge to reconsider his own ruling. Like, you got it wrong, reconsider your own ruling. And by the way, can you please, in addition to reconsidering your ruling, just don't allow the January 6th committee to enforce it while I appeal. Ultimately, if Judge Carter denies this relief, what Eastman will do is he'll then appeal to the Ninth Circuit. He'll ask the Ninth Circuit to stay the enforcement of the subpoena pending the appeal as well. So that's his next move. But Carter's going to deny this relief by Eastman. But I do hope that this is a perfect opportunity for the January 6th committee to go in there and to get Trump into that courtroom. So I hope they take my advice. I'm Ben Meiselas from the MeidasTouch Network. Hey, hit the subscribe button right now. We're on our way to 1 million subscribers, thanks to you. And in addition to hitting the subscribe button, make sure you check out our Patreon website, patreon.com/MeidasTouch. patreon.com/MeidasTouch. We have lots of exclusive content there. You can join one of the membership tiers, and it helps grow this independent platform. We have no outside investors, so it goes a long way. That's Patreon, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
MeidasTouch is unapologetically pro-democracy, and look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, "It Wasn't Rigged, You're Just a Loser," at store.meidastouch.com. That's store.meidastouch.com.